Hi, this is Sean Keith from Keith Law Group, and I'm here with your June update in regards to the acetaminophen MDL. We're going to cover a couple of topics today. The court has come out with two orders really of significant interest since the last update I gave you. The first one is a tale of two states, and this is a really important decision that the court has made. There were two cases. One was the Washington case that or the Anderson case that came from California. Mrs. Anderson had sued Target, Walmart, and another retailer. And then you have the Crystal Washington case, which was from Texas, in which she had sued CVS. Both of those cases, the judge ruled on in one order. And what the judge ruled was the bad news first. If you are from Texas, this could be very significant. Now, it's early yet, so we don't know for sure. But the court did rule that Texas has a Safe Harbor Act, which means, if you remember last time we talked about preemption, if you had a conflict between state law and federal law. The state of Texas has passed a law that says if a manufacturer or retailer, in this case CVS, follows the FDA guidelines, then they are in a safe harbor and cannot be sued. If they follow the warning label from the FDA, then they can't be sued. They tried that same argument in California. However, the judge, Judge Cote, ruled that in California, there is no such law. So what we know right now is if you're in Texas, if Texas has jurisdiction over your case, then we're gonna have to look at that very closely. And there is a chance that your child's case could be dismissed. If you're in California, we know that you're safe. And I've told you all along, rulings will affect this case as we go along. This is one that's pretty significant. I don't know if it's going to affect all Texas cases. I don't know if we're going to be able to look at whether other jurisdictions apply. So don't give up if you are from Texas, but it is important to know. If you're from California, don't get overconfident. Other things can happen. But that's the Washington and Anderson rule that came down on May 15th. The other significant ruling or order is more administrative. The court entered an order just recently that about what's called the Plaintiff Fact Sheet. And this is a Plaintiff Fact Sheet. Every multi-district litigation like this one has what's called a Plaintiff Fact Sheet. It means that within a certain period of time from filing a lawsuit, you have to fill out certain forms, kind of like you did for us on your questionnaire. So, and if you don't do it, and it's probably going to be about 60 days from the time that your lawsuit's filed, and we'll probably ask you to fill it out before we even file your lawsuit to ensure that we don't waste time or money in filing it if you're not going to fill it out. But what it means, we'll take the information you've already given us, combine it with new information, but you may get one of these in the mail, and you may get two if you have two kids. They have a second fact sheet if you have additional children. And if you have children from two different fathers, they have a separate fact sheet for that. But these are coming. We'll be able to fill out some of the information with what you gave. The rest of the information you need to provide to us. It's Plaintiff Fact Sheet. I'll talk more about that later. That's it for this month's update. If you have any questions, please feel free to reach out to Keith Law Group or reach out to me, Sean Keith, or our co-counsel, Beasley Allen. If you're getting requests for information from either my law firm or Beasley Allen, please respond to those quickly. It's very, very important. Again, thanks for your time, and until next month, take care and be well.